So what in the world does a corporate whistleblower have in common with a mob boss? Well, you might be surprised to hear that there's a powerful law that actually connects the two. Today we're going to break down Beck versus Prupis, a fascinating Supreme Court case that dives right into this strange intersection. And, believe me, it has huge implications for anyone who dares to speak out against their employer.
Yeah, it all comes down to this one kind of wild question. If you get fired for exposing illegal stuff happening at your company, can you actually sue them using the exact same law that federal prosecutors use to take down organized crime? The answer? Well, it's probably not what you think.
Okay, so to really wrap our heads around what's at stake here, we have to start with the law itself. And this isn't just any old law. We're talking about a legal powerhouse, one that was originally built for a very specific and, frankly, a very dangerous kind of criminal.
And that law is the RICO Act. It was passed back in 1970, and its main job was to give the government a brand new weapon to dismantle these complex criminal organizations. Think of it as the legal sledgehammer that helped bring down some of the most notorious crime families.
But here's where it gets really interesting. The power of RICO isn't just for taking on mobsters. See, the law defines racketeering activity really, really broadly. It includes a whole bunch of crimes that, start to look a lot like corporate misconduct. Things like bribery, wire fraud, and money laundering. And that right there opened the door for this law to be used in a totally different arena, the corporate world. And that super broad definition of racketeering, well, that is exactly what brings us to our case. This isn't a story about gangsters. It's a story about a corporate boardroom, a high-level executive, and a decision that was about to change his entire life.
All right, so on one side of this, you've got Robert Beck. He was the president, the CEO, a director at Southeastern Financial Corporation. And on the other side, the corporation itself. Beck claimed that he had discovered that other directors were involved in some pretty serious financial shenanigans.
So what happens next plays out like a classic whistleblower story. Step 1. Beck finds financial activity he's convinced is illegal. Step 2. He does what you're supposed to do. He reports the wrongdoing to the regulators. And then, Step 3, the board of directors retaliates, and Beck gets fired.
So Beck fights back, he sues, and he uses the RICO Act to do it. His argument was actually pretty powerful. He said, look, my firing wasn't just some case of wrongful termination. No, he argued, it was a crucial part of the company's conspiracy to commit racketeering. It was an action they took specifically so their illegal scheme could keep going. And that teed up the big question for the Supreme Court. Does getting fired for blowing the whistle count as an injury you can sue for under RICO? So, let's get to the decision and see how the court answered that question. This is where the legal interpretation gets incredibly specific, and the consequences? They become huge. The Supreme Court's answer? It was a clear, direct, and very forceful no. They ruled that an employee absolutely cannot use the RICO Act to sue their employer for firing them. And this was a massive blow, not just for Robert Beck, but for whistleblowers everywhere. Okay, so here's the core of their logic. The court drew a very, very fine line. They said that to sue under RICO, your injury has to be caused by the racketeering activity itself. The actual fraud or the bribery. The court decided Beck's injury wasn't the financial fraud. His injury was being fired. And getting fired, in their view, is not an act of racketeering. It's just part of the cover-up.
Let's put this in much simpler terms, right? Under this ruling, if the mob is running a protection racket and they break your legs for not paying up, you can absolutely sue them under RICO. But if your bosses are running a fraudulent scheme and they fire you for reporting them, you cannot sue them for that firing under RICO. It's all about what directly caused the harm.
So one executive gets fired and the court makes a pretty narrow ruling. Why should we care so much? Well, because this one decision set a precedent that fundamentally changed the entire game for corporate whistleblowers.
So what's the reality for whistleblowers after this case? Well, first, getting fired for exposing corruption is not on its own a RICO injury. Second, any lawsuit has to focus on harm caused directly by the criminal conspiracy, not by the actions taken to cover it up later. And third, this decision basically forces whistleblowers to look for other, more specific employment laws for protection, laws that might not have the same financial punch as a big RICO lawsuit.
So here's the bottom line, the crucial takeaway. Beck versus Prupis took this incredibly powerful law, one designed to fight organized crime, and it essentially built a wall around it, blocking it off as a tool for one of the most common ways companies retaliate against whistleblowers, by firing them. It put a serious limit on how this mob law could be used inside the boardroom.
And that leaves us with a really fundamental question to chew on.
Is this a necessary ruling that protects businesses from getting hit with massive RICO lawsuits every single time an employee is let go? Or does it strip away a vital protection, leaving the very people who are brave enough to expose wrongdoing dangerously vulnerable? That is the complicated legacy of Beck versus Prupis.